Dear students, subscribers and the viewers, welcome to the IAS Mentor. In our previous lecture in the series Indian Polity, we have started the topic of directive principles of state policy. And we'll continue with the directive principles of state policy. In this lecture, probably in the next lecture, I'll complete the entire directive principles of state policy. Again, as I said, from the examination point of view, there may be one or two questions in the preliminary examination. And if at all any question that may come in the mains, probably the question can come from the topic of what is called as a uniform civil code. Now, what you have learned, let me just quickly recap what you have seen in the last class. So, we started with the idea of what is these directives or directive principle is basically to provide some directives to the state, so that any government that is formed will know as to what they are supposed to do in order to ensure what is called as the welfare to the people. And in fact, the idea of these directive principles has been taken from the Constitution of Ireland. And directive principles of state policy, similar to that, not exactly this, existed in the Government of India Act 1935, and that is basically what is called as the instrument of instruction. So, all these things we have learned. And most importantly, we have learned that the DPSP is non-justiciable in character, that it is only a moral obligation upon the state. And what is the reason why it is kept as a moral obligation? We have already seen as to what kind of debate has happened in the Constituent Assembly. And apart from that, today, if you look into the directive principles of state policy, they are classified, although not in the Constitution, into socialistic, Gandhian, and the liberal intellectual principles. So, what are socialistic principles? We have covered it in the last class. So, in this lecture, we will continue with what is called as the Gandhian principles. And after I complete Gandhian principles, I will also get into one important area which may also be relevant for your mains examination, which is what is called as a uniform civil code. A very important area, one question that has been asked probably in the mains examination from the DPSP in the last 10 years is only from the uniform civil code. So, it is very, very important. Alright, so before I get into that, so as I used to say in all the classes, for the maximum benefit of this particular series, I would request the students to watch it in a chronological order. So, if you watch it in a chronological order, probably your entire preparation for Indian polity would be done. But yes, you will have to keep adding some current affairs. We will try to incorporate something, but we are not sure in which year probably will be giving the examination. So, probably adding some current affairs could really help you in doing in your examination well. But otherwise, the conventional knowledge would be completely covered. And whenever I discuss something, if there is any current update, I will also try to cover upon all those things as well. And if you watch this series completely, it will immensely benefit most of the candidates. So, with that, we'll just enter into the next topic we are there to cover, which is what is called as the socialistic principles. Sorry, the Gandhian principles. Now, what are these Gandhian principles? So, the basic understanding for the Gandhian principles is that these principles are reflecting the ideas of Gandhiji. So, Gandhiji had his own ideas. Say, for example, he believed in what is called as rural economy. So, he believed in cottage industries, cooperatives, thereby promoting rural economy. He believed in protecting the milch and other, preventing the slaughtering of milch and other animals. He believed in the idea of what is called as prohibition of intoxicating drinks. He believed in the idea of what is called as self-reliance and the local self-government. So, most of these ideas were given effect in the Constitution, and they were given effect in the Constitution in part 4, that is in the directive principles of state policy. So, some of his principles also got position here, and that is what you are going to see in today's lecture. And once we complete that, we will also go to what is called as the Uniform Civil Code, but that is not part of the Gandhian principle. The Uniform Civil Code is part of what is called as the liberal intellectual principles. Liberal intellectual principles means these are principles which were far ahead of their time. These are principles which are very liberal in terms of their ideas, and that would make India as a liberal democracy. So, that's basically what is liberal intellectual principles. So, in that we will touch upon Uniform Civil Code today, and the remaining things I will take it up in the next lecture. But I try to cover all the Gandhian principles today. So, come to the Gandhian principles. So Article 40, Article 43, Article 43B, Article 46, Article 47, Article 48, they're all reflecting the ideas of what is called as the Gandhian principles. So what these articles, we'll try to understand that with some examples. Say for example, Article 40. Article 40 is talking about what is called as the village panchayats. So when you take off village panchayats, so because Gandhiji believed in the idea of what is called as local self-government. So he believed that the government institutions has to come from the grassroots. Although his idea was not completely accepted and not much of his ideas reflect in the constitution, but some of his ideas with regard to the grassroots democracy was given effect in the directive principles of state policy. But however, it is today realized, this village panchayat, by virtue of what is called as a 73rd Constitutional Amendment Act in 1992. In fact, you might be knowing that the 73rd Constitutional Amendment Act 1992 has given constitutional status to panchayats in our country today. Okay, so today they're all having constitutional status. It is not that the panchayat did not exist before that. It existed after the commencement of the constitution, and even before the commencement of the constitution, the panchayat system existed in our country. But what has changed after the 73rd Constitutional Amendment Act is the 73rd Constitutional Amendment Act has given what is called as a constitutional status today to the panchayat system. So the 73rd Constitutional Amendment Act has given constitutional status to the panchayat. And what about the 74th Constitutional Amendment Act? The 74th Constitutional Amendment Act has also given constitutional status to a particular body. So, and what is that particular body? If you know the answers, you can put it in the comment box. All right. So this is the way that I know that the students are participating in my class. So that's the reason I put some questions during the class. All right. So this is Article 40. Article 43 is talking about to promote cottage industries. So cottage industries are basically small scale industries, micro industries or small scale industries. So this is the way that Gandhiji believed in developing what is called as rural economy. So to promote cottage industries, a number of initiatives has been taken by the government. Say for example, we have Khadi boards at the rural level. So we have the government sponsors to promote what is called as micro and medium scale industries, especially the cottage industries. So these are all examples of steps taken by the government to promote what is called as cottage industries. Today, a lot of loans are given under the Mudra scheme, especially to the scheduled caste, scheduled tribe, women and all those people. So these are all examples of how the government is taking initiatives to promote what is called as the cottage industries. And then Article 43B to form cooperatives, to control and to manage cooperative society. So in this regard, to allow people to form cooperatives and to manage those cooperatives and administer those cooperatives in a democratic manner, the government has enacted what is called as a Cooperative Societies Act. So today the Cooperative Societies Act manage or provides a provision as to how the cooperatives in our country has to be managed. So to give effect to Article 43B, the Cooperative Societies Act has been enacted. And then we have Article 46 of the Constitution, which talks about to promote educational and economic interest of scheduled caste, scheduled tribe and other weaker sections. So this is in idea of Gandhiji that he wanted every sections of the society to get what is called as education, or his idea of what is called as Sarvodaya, or the well-being of everyone. So in line with this, today a lot of initiatives has been taken by the government. Say for example, the government is coming with the concept of reservation to the scheduled caste, scheduled tribe, and the government is providing free residence, especially to the girls from the vulnerable sections. So these are all examples of how the state is implementing what is directed under Article 46 of the Constitution. So come to Article 47, to prohibit consumption of intoxicating drinks, which is injurious to health. Now, in line with this, today some of the states have enacted legislations which is putting restrictions on consumption of intoxicating drinks. In fact, some of the states have put restrictions on the sale and consumption of what is called as intoxicating drinks. Say for example, the states like Bihar, and even before the state of Bihar, the state of Gujarat, they all have restricted and they have put a ban on the sale and consumption of intoxicating drinks. So some of these measures are taken by the states, and it is majorly to implement the provision of Article 46 of the Constitution. So that's basically what you'll have to understand. In fact, when these restrictions were imposed, some of in some of the laws in some of the states were challenged in the Supreme Court, that putting restriction on the sale and consumption of alcohol would be violative of Article 19 in the Constitution. So how is it related to Article 19? Because Article 19 talks about what? Article 19 talks about right to freedom of trade and profession. So the people who are affected because of the imposition, the ban that was imposed on the sale and consumption of alcohol, so they challenge that it is affecting the right to profession, trade under Article 19 of the Constitution. So then the matter was looked upon by the Supreme Court. The Supreme Court said the right to trade and profession under Article 19 is not an absolute right, and it can be restricted on the grounds of what is called as public interest. To be very specific, it can be restricted on the with regard to protecting the public health, because these are all intoxicating drinks which can affect the health of the people. So therefore, the state is very well within its limits to impose what is called as reasonable restrictions. And on top of that, there is also directive which is there in Article 47 of the Constitution. So the Supreme Court has upheld these limitations that was restricted by the state, especially in the state of Gujarat and Bihar. But however, when the restriction was imposed in the state of Bihar, the matter has gone to the Patna High Court. The law that was imposing restrictions on the right to the law that was imposing restriction on the sale and consumption of alcohol in the state of Bihar, it has gone to the Patna High Court, where apart from Article 19, it was also challenged on the grounds of Article 21. So then the Patna High Court has given an interesting judgment. So let us take a moment to understand that. When the matter has gone to the Patna High Court, it was argued in front of the Patna High Court that the imposition of ban may not be seen not only the violation of Article 19. When it was argued that it was a violation of Article 19, then the Supreme Court has already said that the right to trade and profession is not an absolute right and it can be restricted reasonably. But in the Patna High Court, it was argued it was not only a violation of Article 19, but it is also a violation of Article 21 of the Constitution. A new dimension has been brought in. The petitioners argued, most importantly, if you restrict me from consuming alcohol, then you are also depriving my right to life and liberty. It is my personal liberty to drink alcohol. If I want to have a peg of alcohol in my home, in my place, without disturbing others, how the state can regulate all those things? If the state is unnecessarily restraining me or putting a restriction on this particular regard, you are depriving me of my liberty. So liberty, we have already seen, it has a very wide definition. Liberty not only means that somebody is arbitrarily detained, but liberty would mean that as a free man, as a free individual, in pursuit of your happiness, you should be free to do certain things. Of course, without affecting others in the society. So the argument here is that if I want to have an intoxicating drink which will make me happy and which I am doing it in my personal space, in my home, without disturbing others, how does it matter to the state? What is the business of the state? Why the state is restricting all those things? And if the state is restricting all those things, then it is an unreasonable restriction. And therefore, they are depriving me of my right to life and liberty under Article 21 of the Constitution. So this is something that the court has to decide. In fact, this matter is still pending in the Supreme Court. The Patna High Court has viewed this to be violation of Article 21, but however, on a subsequent appeal, right now the matter is pending in the Supreme Court. So it would be very interesting as to how the Supreme Court is going to look into this particular matter. Will the Supreme Court review its previous judgments? Because earlier it was challenged only on the grounds of Article 19, but now also on the grounds of Article 21. So it would be really interesting as to how the Supreme Court will look into this particular matter. Let the judgment of the Supreme Court come, but how many of you think personally, the students who are watching this particular lecture or the viewers, how many of you think that the total ban on the consumption of alcohol may be seen as violation of Article 21 of the Constitution? So this is just your personal opinion, okay? So if you want to put your opinion, you can put it in the comment box. All right. So come to the next article, that is Article 48 of the Constitution. To prohibit slaughter and cows and other milch animals to improve their breeds. Sorry. In fact, this is also the thought of the idea of Gandhiji. So in line with this particular article, today we have a lot of initiatives that has been taken by the government. Especially many state governments have prohibited the slaughter of milch and other cow and other milch animals. So they have been prohibited. In fact, there is in some of the states there's a complete prohibition on the slaughter of cow and other milch animals, especially in states like I think Uttar Pradesh, Rajasthan, Madhya Pradesh. In some of these states, there's a complete ban on the slaughter. In most of the states, they are regulated. There's no complete ban, but there's a regulation of the slaughtering of cow and other milch animals up to a certain age limit, because up to a certain age limit, they are very productive. But after a certain age limit, they might become unproductive or they will become unproductive. So under such a circumstances, they can be slaughtered. So all these laws were majorly aimed at ensuring what is given under Article 48 of the Constitution. But however, remember, as I already discussed, whatever is given in Part 4 of the Constitution, that is the directive principles of state policy, they are not legally enforceable. But however, the state is free to enforce all those things. Okay. And once they enforce it by a way of a law, then people have to follow it. Okay. So that is what you'll have to understand. Once they bring in a law to implement these things, by a way of which people may get the right also, people may have a legal obligation also to follow all those things. That's basically what you'll have to understand. So now we are moving to the next principle, that is the liberal intellectual principles. Now, one important theme that UPSC has been asking in the prelims examination is that they can give a list of directive principles of state policy and they may ask you to identify which of the above is a Gandhian principle, which of the above is a liberal intellectual principles, or which of the below given principles are part of what is called as socialistic principles. So you should be in a position to segregate and identify what type of principle is this in case if they ask you. And also you should be in a position to differentiate between the fundamental right, DPSP, and the fundamental duties, which I'll subsequently discuss, because that's also one important theme where UPSC has been asking the questions. So okay, so with that you'll have to be very clear. Now with that, I'll move to the next important article in the directive principles of state policy, that is Article 44 of the Constitution, which talks about what is called as Uniform Civil Code. To understand this particular topic, we'll have to understand number of things. We'll have to first divide this entire topic into number of subtopics. So first we'll have to understand as to what is this Uniform Civil Code. What is Article 44 is saying? That the state shall endeavor to have what is called as an Uniform Civil Code. That means Article 44 is giving a directive that if possible, the state shall try to bring in what is called as an Uniform Civil Code. So the first question is, what is an Uniform Civil Code? And today, do we have an Uniform Civil Code in our country? No, we do not have an Uniform Civil Code. There's only one state in our country which is having an Uniform Civil Code, subject to some exception. So what is that particular state? If you know the answer, you can put it in the comment box. Otherwise, I'll discuss that in the end of the discussion. End of the lecture, I'll discuss about it. So what is Uniform Civil Code? Do we have an Uniform Civil Code? No, we do not have an Uniform Civil Code as of today. And what was a discussion that was happening related to the Uniform Civil Code in the Constituent Assembly, and why it became part of what is called as the directive principles of state policy? What are the debates that are surrounding this Uniform Civil Code presently? Because there are some section of people who are supporting the idea of Uniform Civil Code. There are some sections of the people in our country who are not in favor of this Uniform Civil Code. So what basically is the debate? What are the crux of the points around which it is centered? And then of course, what are the challenges probably if you have to move forward with an Uniform Civil Code? What is a view that has been taken by the Supreme Court of India with regard to this Uniform Civil Code? In fact, most of the cases, the Supreme Court was a mere spectator for this particular concept of Uniform Civil Code, because that's a political decision to make. So the Supreme Court was not very vocal about the idea of Uniform Civil Code, but in certain judgments, the Supreme Court of India has also been very vocal favoring having what is called as an Uniform Civil Code. Especially two important cases. One is the Shah Banu case in 1985. Another is the Sarla Mudgal case in 1995. So we'll touch upon these things also. And apart from that, time and again, the government of India has referred this matter to the Law Commission of India. So the Law Commission of India is an expert body, the expert body of legal members who will usually give opinion to the government of India on various legal matters, what kind of law they are supposed to have, whether to amend a certain laws, whether to bring in new laws. So all these things may be referred by the Law Commission of India. So as a part of our discussion, we'll also touch upon as to what is the opinion of Law Commission of India with regard to what is called as Uniform Civil Code. Now, once we discuss from all these dimensions, we are broadly covering the Uniform Civil Code from different dimensions. So that will help you to handle the questions in case if it is asked in the mains examination. So the first point that you have to understand in the entire process is what is an Uniform Civil Code. So think it like this. Today we have an uniform criminal law. That means the punishment is same for people across different religion, different caste, whatever it is. Whoever commits a particular criminal offense, everybody will be given the same punishment under the law. So today we have uniformity with regard to the criminal laws, subject to some exceptions. I'm not concerned about the exceptions. But when it comes to personal laws or when it comes to civil laws, especially related to the personal matters. So within the civil laws, another subcategorization is basically within the personal matters. When I say personal matters, matters like marriage, matters like divorce, matters like inheritance of property, matters like adoption of child. So these are all civil matters but more personal in nature. So when it comes to personal matters within the civil laws, there is no uniformity in our country. Most of these things, that is laws related to marriage, divorce, inheritance of property, adoption of child. So all these things in our country today, if you see these personal matters or the laws governing these personal matters in our country, most of these things are regulated or most of the things are based on what is called as the religious practices or customs. And that is not uniform. It is different in different religions. Say for example, I'm not saying we are not having a law, but these laws are not uniform. And the laws are majorly based on the religious customs, beliefs, traditions, and practices. Say for example, take the Hindu Marriage Act. So the Hindu Marriage Act is applicable only to the Hindus. So if you look into the Hindu Marriage Act, it talks about the various provisions related to marriage, divorce, maintenance and all those things, but it does not apply to all the people in our country. It applies only to Hindus, and apart from Hindus, it also applies to Sikhs, Buddhists and the Jains. So these are the categories of people to whom it applies. Okay, but however, it does not apply to the other categories of people. And say for the Christians, there is something which is called as Christian Marriage Act. For the Muslims, there is what is called as the Muslim personal laws. For the Parsis, they have their own set of laws. So if you look into these personal matters, today the law is not uniform. And because the law is not uniform, you can ask me what is the problem? The people who are against not having a uniform civil code, or the people, in other words, the people who favor the uniform civil code, for whom uniform civil code is must, they say that unless and until we have a uniform civil code, it is going to bring in what is called as inequality in the society. There won't be inequality. For example, they put across this particular idea. Say for example, in certain religion on divorce, the maintenance is given as per the laws in certain religion. But whereas in certain religion, when women get divorced, they are not entitled to get maintenance. Say for example, under the Muslim personal law, there is no provision for maintenance for a woman once they are divorced by their husband. And in also certain religion, there is no right to equality when it comes to what is called as property inheritance. Probably the male is given more preference than the female. So in this way, if you don't bring in a uniform code, if you do not have a uniform law, it may result in violation of the fundamental rights, especially the principle of equality. Not necessarily the principle of equality. It is also going to have what is called as result in gender injustice. Certain gender may be in a disadvantaged position in relation to the other gender. So all these things are not in line with our constitutional values. All these things are not in line with our constitutional ideas. And of course, apart from that, they also say that if you talk of secularism, there should be a single law. There cannot be different laws for different categories of people. or people from different religion, that does not go with the idea of what is called as secularism. So secularism means uniform law. That is basically what is the understanding you should have, as per people who wanted to have uniform civil code. So don't think it is my personal opinion. I'm not reflecting anybody's opinion. Probably I'm trying to give the opinion of both the sides so that the students might have a better idea, and based on which you can come out with your own arguments. So basically, people who believe in the idea of uniform civil code, for them, what is the thing? Having an uniform civil code would help in ensuring equality, ensuring the fundamental rights, prevent gender injustice, and also reflects and establishes the principle of secularism. But on the contrary, there are a lot of people who are against this idea of uniform civil code. So people who don't believe in this idea of uniform civil code, they feel that the uniform civil code directly goes against the religious rights of the people, because Article 25 talks about what? Freedom of conscience and the right to practice, profess and practice the religion, practice, profess and propagate the religion of their choice. So once you bring in uniform civil code, it may interfere with the religious right. So there is a direct clash between right to freedom of religion and the idea of what is called as uniform civil code. So both cannot go together. And most importantly, these religious practices based on which today a lot of personal things are followed. So these are all very sensitive, and hence you cannot immediately bring in an uniform civil code. And when you bring an uniform civil code, there is a possibility that the majority culture might be imposed upon the minorities, and that may also go against the religious freedom of the minorities. So therefore, this is a very sensitive matter, and hence there is no need for uniform civil code. And in fact, the greatest strength of our country lies in what is called as diversity, and hence this diversity and the plurality in terms of the practices when it comes to personal matters has to be respected. So there is equal points from both the sides, people who favor uniform civil code and people who opposes uniform civil code. But this debate of whether to have a uniform civil code or not to have a uniform civil code is not a new debate. This debate is as old as the debate in the Constituent Assembly. Even in the Constituent Assembly, all these debate has happened. So there were members who favored this idea of uniform civil code, especially for protecting the fundamental rights, ensuring equality, gender justice. But there were members who opposed this idea of uniform civil code, saying that it will go against the religious rights. In fact, members who oppose this uniform civil code, they said Article 25 and uniform civil code may not be compatible, because some of the members in the Constituent Assembly wanted this uniform civil code within part 3 of the Constitution, that is in the fundamental rights itself. But then this argument was not agreed, because Article 25 and uniform civil code, if both are in part 3 of the Constitution, they may conflict with one another. So finally, as a compromise, the Constituent Assembly decided, okay, we'll have this uniform civil code in the Constitution, but not in part 3, but we'll have this uniform civil code in part 4 of the Constitution. This was a view that was taken by some of the members who were neutral to this idea of uniform civil code, like Dr. B.R. Ambedkar. So finally, this uniform civil code was placed in part 4, which means it is not a legal obligation for the state to come out with an uniform civil code. It's only a moral obligation. That means as and when the society is more advanced, the society is more progressive, then at that point of time, the state can think about bringing what is called as a uniform civil code. That's a basic understanding you should have. So of late, many of the states are again reigniting this particular idea of what is called as uniform civil code. That's why it may be relevant for the examination. So now you have understood what is an uniform civil code, but today we do not have a uniform civil code. We also understood the pros and cons of the uniform civil code. We have seen the discussion that has happened in the Constituent Assembly. But most importantly, let us also try to understand as to what is the view that was taken by the Supreme Court of India. So in fact, the Supreme Court of India is much neutral to this concept of uniform civil code in most of the cases. But in two important cases in the history of India, the Supreme Court was very much vocal of having what is called as an uniform civil code. In fact, they said that it is better to have an uniform civil code. So what are those two cases? One in the history is the Shah Banu case, 1985. And the next is the Sarla Mudgal case, 1995. So a little bit of brief facts and what is the judgment of this particular case could also be relevant for your understanding. If you see the Shah Banu case in 1985, now Shah Banu was a woman from a Muslim religion, and she was divorced by her husband in her late 60s. And I think the divorce was happening through what is called as triple talaq. So through triple talaq, she was divorced way back in 1980s, and subsequent to her divorce, she went to the court seeking what is called as maintenance from her husband, because she was very old and then she is not able to take care of her. So she was asking for a maintenance, and this was challenged by her husband in the court, where he said that he is not liable to pay any maintenance to Shah Banu in this particular case, because their marriage, divorce, everything is regulated as per what is called as the Muslim personal law, or which is also called as a Shariat law. The Shariat law or the Muslim personal law, which is basically based on the Muslim religious practices and customs. So the husband was arguing that under the Muslim personal law or the Shariat laws, I am not supposed to pay any maintenance. There is no such provision in the law. And our maintenance and divorce are regulated by what is called as the Shariat law. So for me, there is no liability. So ultimately, the court was not able to do anything because the law does not provide for it. But however, after a lot of appeal and all those things from the lower court, the matter has gone to the Supreme Court. Even the Supreme Court was not in a position to help Shah Banu in this particular case, because their marriage and divorce are regulated as per the Muslim personal laws. So the Supreme Court is of the opinion there are certain religious community where they do provide maintenance to the wife, which will allow a woman to have a dignified life. But under the Muslim personal law, the Shariat law, there was no scope for maintenance. So they also found that the laws are discriminatory in nature, or there is no uniformity. So thereby women from different religion might face different issues, and there is also gender injustice. So the Supreme Court was left with no other thing. So they invoked section 125 of CRPC. So they invoked a criminal law, section 125 of CRPC, wherein if you see the section 125 of CRPC, it allows to take criminal action against the husband if the husband is not taking care of the wife. So as per the criminal procedure code, the wife would still, even after the divorce, she would be continue to be the wife of the person if the wife has not married another person. So that is how the criminal procedure code is designed. So the Supreme Court was left with no other option, because under the Muslim personal law, no remedy can be given to the wife because there is no provision for maintenance. But whereas to help Shah Banu in this particular case, the Supreme Court invoked the Criminal Procedure Code section 125 and directed the husband to pay some maintenance. It is not maintenance, some kind of money to take care of the wife, but that is a very small amount. So that is not sufficient for the wife to take care, but somehow they try to provide some relief to Shah Banu in this particular case, but they are not able to get any maintenance from the husband. So that is when the Supreme Court realized that the laws are different in different religion, and it may be discriminatory against women in some religion. So probably it is better the state has what is called as an uniform civil code. So they have passed this particular judgment. But the second case is even more interesting in Sarla Mudgal case. So what is this particular case in Sarla Mudgal? If you see Sarla Mudgal case, so this is a case where a husband who initially was in the Hindu religion. So think about this particular case. A husband who was initially in the Hindu religion, he married a person. So he had a wife, and their marriage was solemnized and registered under the Hindu Marriage Act. And then subsequently, this husband who was married a Hindu woman, without dissolving the first marriage, he converted his religion and he became a Muslim, and he converted himself to Islam. And after he converted into Islam, he married a woman from the Muslim community. So when this happened, so that means the same person, first marriage as per the Hindu law, second marriage as per the Muslim law. So subsequent to the second marriage, the first wife whom he married as per the Hindu laws, as per the Hindu Marriage Act, gone to the court, and she challenged the second marriage. So in her opinion, the second marriage is invalid. Not only the second marriage is invalid, the husband is liable to be punished as per the as per the Indian Penal Code. because the husband is involved in what is called as bigamy. So bigamy means marrying another person when the first spouse is alive. So that is basically what is called as bigamy. And bigamy is a punishable offense as per the Indian Penal Code. So this matter has gone to the Supreme Court. Now the Supreme Court has to see whether these arguments which is made by the first wife in this particular case is valid or not. Now the husband argued he is completely right in whatever he has done because as per the Hindu Marriage Act, he married the first wife. Now then he converted into Islam, and as per the Muslim personal law, because once he converted into Islam, his marriage, his divorce and all those things are to be regulated as per the Muslim personal law. So that is what is his argument. As per the Muslim personal law or as per the Shariat laws, and the Shariat laws allows for polygamy. That laws allows to have more than one wife, or it allows for what is called as polygamy. So I married a woman from the Muslim religion. So I am not liable to be punished because whatever I have done is done as per the law. That is what is his argument. But the first wife argued, whom he has married from the Hindu religion, she argued, if you see the Hindu Marriage Act, the Hindu Marriage Act very clearly says that the second marriage would be invalid if the first marriage is not dissolved legally. So as long as the first spouse is alive, or if the spouse is alive, then the marriage has to be dissolved lawfully, or if the wife is dead or if the spouse is dead, then they can get married. So as long as the wife is alive, the marriage has to be dissolved legally. And without dissolving the marriage, if you get married to another woman, then that second marriage is invalid. Not only the second marriage is invalid, it can also be considered to be an offense of bigamy under the criminal laws. So which is basically the Supreme Court has to decide now. So the Supreme Court has to decide whether the second marriage is valid or the second marriage is invalid. Now the basic question for the Supreme Court is, if the Supreme Court declares a second marriage to be invalid, what will happen to the woman from the Muslim religion who has got married to this particular man? What will happen to her status? How the society will view her, because his marriage will be not considered to be valid in case if the Supreme Court has to say that. What if any child is born out of this particular marriage? So these are a lot of legal questions that the court has to answer, but in this case, the Supreme Court NES has given the judgment that they has given a judgment that the second marriage is invalid. Now why the second marriage is invalid? Because the first marriage under the Hindu Marriage Act was not dissolved as per the law. And in the absence of that, the second marriage would be invalid. And further, the Supreme Court also questioned the religious conversion. While the Supreme Court accepted that it is the freedom of conscience of an individual and to practice the religion of his choice and to get converted from one religion to another religion, but the Supreme Court questioned his conscience, his belief in Islam religion or in Muslim religion. In this case, the Supreme Court found that religious conversion is basically a tool to get married. So otherwise, they didn't see that the individual has really had any belief or faith in that particular religion. So on all these backdrop, the Supreme Court said that the second marriage is invalid. But the question is, what will happen to the status of that particular woman in the second marriage? What if a child is born out of that particular marriage? So how do we protect so that women and if a child is born out? So these are all some legal questions that came in front of the Supreme Court, where the Supreme Court thought that the only way we can avoid all those things in the future is by having what is called as an uniform civil code. So therefore, they also recommended to have what is called as an uniform civil code. So these are the two cases probably you can quote if you are in favor of uniform civil code. So it is up to you as to how you wanted to take up your argument in case if a question comes in the examination. But however, you should have both the sides of the argument. So we already discussed on what grounds it was supported and on what grounds it is opposed to have what is called as an uniform civil code. So because the matter is very complex, so to decide on this particular matter, the government of India has referred this to the Law Commission of India to suggest and to give its opinion to the government whether to have an uniform civil code or not to have an uniform civil code. So the latest law commission that we are having is the 22nd Law Commission. So before that it was the 21st Law Commission. It is a practice in the government that the Law Commission will be established every 3 years after the commencement of the Constitution. So in this way, the latest Law Commission we are having is what is called as the 22nd Law Commission. if you see the 21st Law Commission, it was very vocal in saying that there is no need for the uniform civil code in India, because India is a large nation. We'll have to respect the plurality, and plurality means that you'll have to respect the traditions of different religion, and it does not mean that we can govern India only by what is called as an uniform civil code. So uniform civil code is neither desirable nor feasible in our country right now. That's a conclusion that the 21st Law Commission has given. That means neither it is desirable, that means we can run even without an uniform civil code, nor it is feasible. That means even if you want to bring in, there will be a lot of challenges, because you'll have to convince the minorities. The minorities might fear that the majority culture is getting imposed. It can have an impact upon the unity and integrity of our country. So all these challenges are there, and hence let us not go for that. But instead of having an uniform civil code, that is making all the laws same in personal matters to all the religious people, instead of that, the 21st Law Commission recommended something what is called as an incremental approach. Now, what is this incremental approach? Do not bring in a complete change in the laws which is followed by different religious community, but make some incremental changes. Suppose you feel some provisions in any of the religious laws, which is basically you feel in violation of the fundamental right, which you feel basically that it brings in gender injustice. You try to pick and correct only those areas rather than bringing a sweeping uniformity across all the religion, where the 21st Law Commission was open to this particular idea. So that's basically what is called as an incremental approach. Say for example, today the government is trying to bring in changes in the age of marriage of women. So today the government has already introduced this particular bill, which is pending still in the houses of the parliament, where they are trying to improve the age of women from 18 years to 21 years. So earlier the age of women was 18 years. Once this bill is passed, the age of women would be 21 years. This is to ensure equality with men. So the age of marriage for men is 21 years. For women it is 18 years. So it shall also be increased to 21. And once this bill is passed, this will not only make changes in the Hindu Marriage Act, but this will also make changes in all the religious laws in our country. So this is an incremental approach. We are not making changes in the other areas, but only in this area the changes are made in all the laws. So in this way, wherever you find probably some practices in certain personal laws, some traditions or some customs in certain personal laws, which you feel a violation of the fundamental rights, try to make and try to bring in uniformity rather than bringing in a sweeping or a complete reform, which is very challenging in nature. So this is the opinion that is given by what is called as the 21st Law Commission. But again, the matter was referred to the 22nd Law Commission. The 22nd Law Commission, as they have given some of their initial reports, it appears that they are in favor of what is called as an uniform civil code. But anyways, things will be very clear once they come out with a full-fledged report. So this is the basic understanding you should have. So whenever there's a question on uniform civil code, you should basically know what is an uniform civil code, what are the challenges that are surrounding, what are the pros and cons, and if you are someone who is in favor of uniform civil code, you can use the judgment that is given by the Sarla Mudgal case and also the Shah Banu case. If you are someone who is not in favor of it, you can use a recommendation that is given by the 21st Law Commission in your answer. Alright, so then I asked one particular question, that which is the state in India which has got uniform civil code? Today, the only state in India which has got uniform civil code is Goa, subject to some exception. Now for that also you should have a historical background as to how Goa is able to have a uniform civil code. That means in Goa, the people from different religious background, they are all following the same personal laws, subject to some exception, be it Hindus, Muslims, Christians, Parsis, Jains, Buddhists, whoever it is, they are following the same personal law, but subject to some exception. Now, what is the historical background of Goa? So, Goa was under the control of Portuguese. Only in 1960s, Goa became part of India, not before that. So, when Goa became part of India, and already they were having what is called as uniform personal laws. And when they become part of India, we allowed for it. The government, the Indian government allowed, okay, you can continue with your uniform civil code, and thereby they continue to have their uniform civil code. But it is not the case in the other states. So that's the reason Goa continues to have what is called as a uniform civil code, and probably the diversity in case of Goa is not much as it is compared to the larger India. So these are all some of the points that you'll have to probably keep in your mind probably when you write the answers. All right. So with that, we come to the end of the uniform civil code. Very, very important topic. So come to the question that I wanted to discuss. So with that, we are ending this particular lecture. Which of the following is similar to that of DPSP in the Government of India Act 1935? In the Government of India Act 1935, there was something which is similar to that of what is called as the uniform, that is similar to that of what is called as the directive principles of state policy. What is the answer? Objectives, resolution, instrument of instruction, reasonable restrictions, none of the above. So you can put the answers in the comment box. So with that, we are concluding our lecture number 44. In the next lecture, I will complete the directive principles of state policy. If you have any questions or queries related to this particular lecture or any of the other lectures, you can reach out to me through my Instagram account or through my Telegram channel. And you can refer this video to your friends and family members preparing for UPSC IAS examination or other competitive examination. And I'm quite sure it is going to be immensely beneficial to all those candidates. Thank you very much. Keep watching. All the best.